Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana, which is the first one of any substance that we've done pertaining to Louisiana governmental operations in almost a month. As many of you know, I was away in Houston and I did a feature on Baylor University. That was a point of personal privilege, but let me just say this, today's feature may be a little lengthy. It's an awful lot to unpack. So I'm just going to let you know that if you're one that wants to go straight to the heart of the matter, I am going to say that I am a blogger, and so that gives me certain latitudes that folks in the mainstream media may not be able to enjoy, and that is to place my opinion along with presenting facts, and I am about to give you my opinion based upon my attendance at an evidentiary hearing in 3rd Judicial District Court in Farmerville, which took place on Friday, January the 23rd, which is 2 days prior to me filming this. And if all you want is the quick and dirty, you can invest less than a minute because I'm going to express that opinion right now. And my firm opinion is that based upon what I witnessed at that evidentiary hearing, the vast majority, if not all, of the charges against the defendants in the Ronald Greene state trial are going to be dismissed. And so if you just wanted the bottom line, and again, that's an opinion. However, I will tell you that I think if you interviewed anyone leaving that courtroom, they would share those sentiments. You would be hard-pressed not to, in my opinion. But I'm going to provide, through the remainder of this video, so if you only wanted the bottom line, you can go ahead and turn it off. But I'm going to provide some of the specificity that would cause me to make such a statement, because this was one more incredible court hearing. And it's a lot to unpack, but the bottom line is that once the indictments, you will recall from back in mid-December, indictments came down against 4 troopers and 1 sheriff's deputy for various allegations with regard to the arrest and apprehension of Ronald Greene on May the 10th of 2019. Almost immediately, well, literally within days. And I believe, I don't want to be held to this, but I believe that the first one to file may have been Captain John Peters. But each of the defendants, and they're largely duplicative, and you just changed it to fit the particular defendant in question, but they filed a motion to seek a bill of particulars from the state, i.e. from Attorney General John Belton, and at that time Belton was the only counsel handling this thing. Then basically they all allege that, hey, you haven't given us with any degree of specificity what it is my client is alleged to have done. And the indictments are rather generic in saying that malfeasance due to this and so forth, and they said you've got to give us the particulars of what it is you are alleging that my client, and when I say my client, I mean each of the respective attorneys, because they all wound up filing these things, has done. Now, when, I don't know what prompted this, but as most of you know, Hugo Holland joined the case to assist District Attorney John Belton. I'm not going to speculate on why that took place. I know that it did not sit well with Miss Mona Hardin, the mother of Ronald Greene, because of Mr. Holland's extensive past of defending law enforcement officers. And that's what he's done a lot of. But at any rate, he was brought in to assist on this matter. And I think that Mr. Holland stated this as eloquently as he could but he indicated that had he been on this thing from the outset, he would have responded to the state's request for the bills of particular in saying that you're not entitled to that. You get that through the discovery process. However, he said that Mr. Belton, in a chambers meeting with the participants, indicated that he had promised that he would provide the bill of particulars. And so, as Mr. Holland stated, it is what it is. Mr. Holland is pretty emphatic that this should not have been required, and he cited 5 court cases, and I'm not going to bother because we'll be here forever if I started divulging all of the court cases that the different attorneys cited. But he cited 5 court cases that indicated that that this was not something that the state was obligated to do, that it should come through the discovery process. And so now what I want to do is go defendant by defendant and deal with what happened on Friday. And I'm going to start with the most prominent defendant, at least the most prominent. And this is not the order in which they took them up, but I don't see that I have any obligation to go in the order they took them up. So we're going to begin with Corey York. Now he is a master trooper who got by far the most serious of the indictments in that he was charged with 11 counts, 1 count being negligent homicide and 10 counts of malfeasance in office. And I will emphasize that Mr. York is represented by 2 prominent attorneys, one of whom is Mike Small, and the other one being T. Taylor Townsend. Now, for those of you who may not be familiar with the name T. Taylor Townsend, he headed Governor Edwards' super PAC for his election in 2015. He is also the one who basically was brought in to deal with the Kathy Durbin situation, the former State Police Commission executive director. And if you want, you can go back and look at sound off of the very day that Miss Durbin she resigned in January of 2017. But I say that only to say that T. Taylor Townsend and Governor Edwards are pretty close, and so I'll leave it at that. But at any rate, the 2 counselor, Mr. Hugo Holland, I'm sorry, Mr. Holland is assisting Mr. Belton, Mr. Mike Small, and Mr. T. Taylor Townsend. Now, I will admit to you that most of you know I spent an enormous amount of time in courtrooms, and I guess in another life maybe would have been an attorney myself, but be that as it may, I do like to watch good attorneys, and from everything I have been able to surmise, I personally would rank Mike Small in the top 4 of defense attorneys in this state. The other 3 being Louis Oglesby, John McClendon, and Mike Fowler. Now Mike Fowler is on up in age and may not be doing much in the way of practicing now, and for that matter, Mr. Small's not a spring chicken, but from everything I've been able to ascertain, those 4 are kind of the cream of the crop. And when you're dealing with Mike Small, you're not dealing with somebody who fell off the turnip truck. He's extremely shrewd. He's represented former Governor Edwards before. And I'm just going to say this, and we're going to give you the direct link for it. Mr. Small filed on June the 15th, which was only 8 days prior to this hearing. Now, I want to emphasize, this matter was not argued on June the 23rd, but I want to cover it first because, and I'll tell you when it may be argued in just a moment, because I think it's the most compelling document of all. And if I went through and we'd be here for days if I tried to cover each document that was filed with regard to this matter. However, Mike Small on June the 15th filed a motion to quash, which they all have now, filed a motion to quash the subpoena and have the charges against his defendant, who again is Corey York, dismissed with prejudice. And in that document, and I'm going to pull it up, pull up the link for it that I have. You'll have to forgive me, it was just way too much documentation for me to just try to spread all this out. So he is calling for what's called a Castigar hearing, and I believe I pronounced that correct. And that's based on a United States court ruling. And what he is essentially asserting is that Mr. York's Fifth Amendment rights made applicable to the states through the 14th Amendment rights against self-incrimination have been violated. And specifically, what he is saying in there, and we're going to give you the link for it, you can read the entirety of the whole thing, is that LSP launched an administrative investigation into the whole Greene matter. I will point out that he puts in this that matter, that they launched it on September the 15th of 2020, which just so happens to be 5 days after Sound Off made all of this public. So 5 days after we broke the feature with regard to the Ronald Greene matter, LSP sees fit to go ahead and, hey, let's go ahead and see about doing something administratively on this. And so the internal affairs investigator, it's Trooper Talley, he published, or he issued a report dated October the 20th of 2020, okay, October 20th of 2020, and that's an important date for this reason. And I'm going to go directly to paragraph 16, and we're going to read it because I found that to be a very interesting paragraph. It may not stand out to most folks, might not have even stood out to Mr. Small, but I want to read it right here and right now. This is paragraph 16. After Mr. York was interviewed by Senior Trooper Talley, Talley generated and filed an internal affairs report pertaining to Mr. York's participation in the arrest of Ronald Greene. Dated October 20th, 2020, and identified as case number 20-018, it states on page 2 that Master Trooper Corey York was interviewed. In a section entitled, quote, investigative findings, unquote, the author of the report notes, quote, the following information, referring to the contents of that report, was obtained from Master Trooper York's interview, as well as video footage from Trooper Dakota DeMoss and Lieutenant Clary's body-worn camera. And there's a footnote notation that this has been filed into the record in 3rd JDC, that being the report of Mr. Talley. However, I will point out it was filed under seal. But what I want to stress about this October the 20th, 2020, is we're going to provide you with a direct link to an Associated Press article that ran on or about May 24th, 2021. And in that article, it was indicated that Lieutenant Clary had withheld the body camera for almost 2 years until it surfaced, quote, last month, which would have been April of 2021. Now, I want to emphasize that again, and we'll give you the link for the AP article. It was by Jim Mustian, but it says that Lieutenant Clary withheld. Now get this, or as my friend Freddie Phillips will say, watch this right here now. It is being stated that he withheld the body cam video until approximately sometime in April of 2021. And yet, we have, according to Mr. Small, and Mr. Small would never file something into the record, and bear in mind, he's had access, even though it's sealed and we don't, but he's saying, he's making a notation from the report authored by Mr. Talley that says was based in part on the body camera of Lieutenant Clary. And that report is dated October 20th, 2020. So there's certainly, somebody's not accurate here. It's not my part to judge all of the different scenarios that were apparently thrown out about body camera being withheld and this, that, and the other, but I don't know how you issue a report that references, hey, I'm basing my findings on this body camera that supposedly wasn't even available until some 6 months later. Something is amiss. I don't know any other way to say it. Something is amiss. But at any rate, Mr. Small goes on to argue that the state retained an expert, a gentleman named Stoughton, and he issued a fairly lengthy report, some 200 pages, I think, maybe even more. And in that report, he references Talley's internal affairs report. And Mr. Small, now by the way, I should preface by this, when you are called in for an internal investigation by state police, you're informed that, well, number one, you have a right to an attorney, and he waived that. But number two, you have an obligation to be truthful with us in this interview. However, nothing you say in this interview can be used in any way, shape, or form as part of any criminal prosecution. So, and Mr. Small provides the State Police Commission rules and so forth that indicate this, and he cites them and so forth. You can read it yourself. And so Mr. Small is asserting that District Attorney Belton, in presenting evidence to the grand jury, called in this guy Stoughton as an expert witness, and he in turn referenced the material that was in Talley's report. And you can read it about what Small says happened in all this, but he said there's basically no question that Corey York's right to not self-incriminate have been violated. And so now I want to emphasize that was not even argued in court on the 23rd. But in my opinion, unless the state can come up with evidence that this didn't happen, the negligent homicide, well, all of the charges against Corey York are going to be dismissed, and that would certainly include the negligent homicide charge. Now, as to why that was not argued on June the 23rd, as I said, it was filed on June the 15th, seeking a Castigar hearing. Now, the judge, Hugo Holland, said that, Your Honor, because I've only just the judge was expecting to hear arguments on that, but excuse me, because he set the hearing, along with all the other hearings, for June the 23rd at 1:30. However, Mr. Holland stated that, Your Honor, I haven't had time to adequately prepare for this. So what the judge and everybody agreed to was that, okay, once I've issued my ruling on everything else that was presented before the court formally, which he took all of them under advisement and will issue his ruling at a later date. We will obviously stay monitoring that for the next few weeks to see when that ruling may come out. I'm just here to tell you that I think it's pretty apparent that the vast majority, if not all, of the charges are going to be dismissed. So let's go back. I wanted to do all of that with regard to Corey York because he is the one that's charged with the most serious charge, and since that was the most recent filing. Now, rather than beat down the minutia of every single defendant, there's largely it's not a copy and paste and then adjust, well, it is, and then adjust the situation for whatever your defendant is, but they're all arguing the same thing, that these indictments are unbelievably vague, and we're not being given, okay, a specific act on a specific point in a video or whatnot at which my client allegedly engaged in battery against Mr. Greene, because the other 10 counts with regard to Corey York, they all allege malfeasance in office because of batteries that were allegedly committed on that night. But the defense is arguing that, hey, you can't just say copy and paste one indictment after another without spelling out what did he do and so forth. Now, and that was largely the arguments of every single defendant up there. And Mr. Holland stated that, now bear in mind, Mr. Holland is of the firm opinion that the state's under no obligation to provide the bill of particulars. And again, he stated the case law, I may try to pull that up in a second, by which he feels strongly this was not required. But at any rate, at one point he said, it's very simple. Unlike most other police brutality cases, we have this one on video. You put it into the player and you hit the play button. And there, amongst the Ronald Greene supporters, there was a favorable reaction to that. Let me just put it that way. So let me skip to, and you got to forgive me, I've got a ton of notes and I didn't try to organize all of this, unfortunately. I want to skip to the Christopher Harper. Now he is the deputy, the Union Parish Sheriff deputy, who is also among the defendants. And Eugene Sicardo, and I don't think anybody could reasonably get all this stuff memorized. Mr. Sicardo was arguing his contention for why the indictment should be quashed in his client's case, being Mr. Harpin, the sheriff's deputy, that his case should be dismissed with prejudice, repeatedly emphasized, he won't tell us what my client did. And I mean, he drove that home over and over and over again. And it reached the point that he said, what the state needs to do is just man up and provide the specificity of what my client supposed to have done. And he even used some examples. He said, did he spit on him? Did he slap him? He said, I mean, we've got to get the specifics if we are going to defend the charges. So the state needs to man up and provide that specificity. Now, the reason I went to Deputy Harpin after York is because John Belton really did not have any meaningful contribution at all on the 23rd of June, this past Friday. However, he chose to want to be recognized on that one, and in my opinion, and again I'm interjecting my opinion here, it was ill-advised. What happened is Mr. Belton said, Your Honor, I'm 59 years old, I've been practicing for 37 years, and I have never been so insulted in a courtroom in all of my years of practicing. Now, Judge Rogers said, yeah, but Mr. Belton, this is neither the time nor the place. And he was very polite in telling him that. And then Belton was very dogmatic that, yes, it is, Your Honor. He said, my character has been attacked and I have a right to defend myself. And Judge Rogers said, and I'm telling you to stop. And Belton then said, or what? And I was kind of in disbelief. Judge Rogers said, politely, but he said, I think you know what. And I'll just say this, I was seated directly behind Mr. Belton, and there had been other occurrences where there had been verbal, well, there was talking going on that could be heard in the whole courtroom, and that occurred on both sides. And the Judge Rogers opted not to bring his gavel down and ask for decorum. Not that, I don't want to give the impression that this was just a free-for-all, you know, rah-rah, it wasn't, but you're supposed to keep, the audience is supposed to keep their mouths shut during court proceedings, and that did not happen. One of the sheriff's deputies did go and address the issue at one point because it was starting to get out of hand. But since there had been that much, I decided I could utter the word. I mean, I normally would never do this in a courtroom, but I figured there may be a chance maybe Belton doesn't know or what. And so I, myself, did utter the word contempt. And look, I don't want to turn this episode into causing Mr. Belton to be a punching bag, because I think he feels like that's already been the case. You have Hugo Holland, who very diplomatically said that if I had been running this show from the outset, I would have made it clear that we don't have to turn over a bill of particulars. Of course, Mr. Belton has said he has promised that they would, so as Hugo Holland stated, well, we are where we are, or it is what it is. And as most of you know, Mr. Belton was running for Attorney General, and he recently withdrew from the race. And the scuttlebutt that I have heard, and I do not know if it's accurate or not, so I will qualify what I'm about to say with that, is that he's being vetted by the Biden administration for a federal judgeship in the Western District of Louisiana. I can only say this: if that's true, I personally would want a judge who has a little bit thicker skin, because I agree with Judge Rogers when he said this is not the time or the place. And I don't think there's no valid counter argument to that. You don't turn, this is about the defendants. You don't turn, and the state in its case, you don't make this thing personal about, I hate to say this, but look, Your Honor, I just got my feelings hurt. And in my opinion, just making a statement that the state needs to man up and provide that specificity, which they are under a court order to do now, or to answer, which was brought out and that was, he said, Your Honor, we had this date, the state didn't respond, even though they were under an order to do so. It was continued to this date, the state didn't respond, even though it was under an obligation to do so. And I read one of the filings, and it basically says that in this matter, the judge can order the state and give it 3 days to go ahead and get this bill of particulars. And they cited the court case for that. But Mr. Sicardo, he said, Your Honor, we've already had the Kentucky Derby, the Preakness, and the Belmont, and yet in our horse race, we haven't even made it to the starting gate. Now, in addition to the bill of particulars, there was request for discovery. Mr. Holland supplied a flash drive that I think had some 265 gigabytes of material on it, and then they did a supplement that had a CD that had, I don't know, 75, I don't know whether it was meg or what, but yeah, probably was megabytes. But at any rate, the attorneys were basically arguing that they want us to do their job for them. And quite frankly, I don't think making a statement that you need to man up should have required very thick skin to withhold. And quite frankly, I think that D.A. Belton not only erred in letting them have the satisfaction of knowing that they got under his skin, but number two, I would emphasize that he's not just an attorney, he is also a public figure. He's an elected public figure, and you just have to have thicker skin than that. Now, Mr. Sicardo, after this whole, Mr. Sicardo did state publicly, he said, to the extent that Mr. Belton feels that I have made offensive commentary, I certainly apologize. And then Mr. Belton said, okay, then, Your Honor, I accept the apology. I thought that was noble of Mr. Sicardo to do, because I am going to be blunt, I don't think an apology was even necessary. When you are in a courtroom and these attorneys are going at each other, this is not tiddlywinks, okay? And I know we've covered the Murphy Painter trial. Well, during that trial, the assistant U.S. attorney, Patricia Jones, at one point, of course the jury's not there, said, Your Honor, Mr. Fowler has been using some characterizations of me that I don't appreciate. And Mr. Fowler, who will never be bashful in front of any judge, he said, Your Honor, he said, she is in a position trying to send my client to federal prison, and I'm supposed to be Mr. Nice Guy? No, Your Honor, that's no. And I would suggest to Ms. Jones, now bear in mind, Mr. Fowler is quite on up there in age, had a long and storied legal career. Ms. Jones, on the other hand, is fairly young. And so he said, and I would suggest to Ms. Jones that if she intends to have a long career in this, she needs to grow some thicker skin. That's a verbatim quote from Mike Fowler. And I'm sorry, but I feel that way about Mr. Belton. Now, it's not to say Mr. Belton may not be a very honorable man. I'm sure he is. He apparently gave his word that he would provide a bill of particulars. And at least Mr. Holland kind of, I guess, feels like that's put him in a predicament. But as he says, it is what it is. So I could go down on a whole bunch of the counts that I'm making an executive decision right now not to do. But I can just tell you that there were numerous instances where Mr. Holland said, look, Your Honor, I'm not going to be able to fix that. And I will cover one, and that's John Peters. Although I don't know that he said I'm not going to be able to fix that on this particular issue I'm about to discuss. Peters is the captain, or was the captain, of Troop F, so he would be the high-ranking, that's what a captain is. A captain over troop, you are the ultimate. And he has been indicted allegedly for, well, when they asked for particulars on what it is Mr. Peters is alleged to have done with regard to either obstruction of justice or tampering, the tampering that required or would be necessitated for the obstruction of justice, the state provided two statements that were allegedly made by Mr. Peters, one of which was, look, just bury that in the report. Well, the defense counsel, and I believe that's Ms. Buckle, I believe. I'm sorry. Well, just if I got that name wrong, I'm sorry. It's just too many attorneys that I'm not familiar with, having seen practice. She said, look, by their own admission, it's in the report, so all you have to do is read it. Maybe it's, quote, buried, but it's in there. And then the other thing is that Mr. Peters allegedly said, look, don't turn the body camera video over to the DA's office unless they ask for it. And all I can say is there was such a point made about, DA Belton not having the body cam. He said, I don't have the body cam. And all I can say is, well, you reckon you might could have asked? And like I said, I don't want this to have been turned into a beat up on John Belton scenario, but there's just no denying some of the things that took place in the courtroom, not the least of which, and I haven't even scratched the surface of a lot of the specificity, but I don't want this video to become extremely lengthy. I've got a lot of notes of when Hugo Holland would say, look, Your Honor, I'm not going to be able to fix that. Going back to Peters, Judge Thomas said, well, gee, we don't even know who that statement was made to. He may have made it to his wife. And of course, I'm sure that Mr. Peters, or well, I can say Mr. now, he's retired. I'm sure his defense attorney loved hearing that, and I believe that her last name is Buckle, but if I botched it, I'm sorry. I'm sure she loved hearing that. And Mr. Holland said, Your Honor, and Mr. Holland had stated that numerous times, I can't argue with defendant's position. Defendants are completely correct in the filings and this and that and the other. But he said, Your Honor, even if I was able to prove that Mr. Peters made that statement to someone whom he would have had authority over or could have been influenced, we're right back where we would be anyway. So, I mean, anybody can make commentary on anything that I've said, and you can attack the messenger if you want, but I'm just telling you that this was if we were talking about a football game, in my freshman year of high school, LSU was going to play Rice on its home stadium, and my dad asked me how much I thought LSU would win by. And by then I was into sports, and I said, I'll predict LSU by 67. Both my dad and my mom busted out laughing. They said, son, that's ridiculous. There's no way you're going to score 67 points in a football game. All I can tell you is the final score was LSU 77, Rice nothing. I underestimated by 10. Carlos Carson caught 5 touchdown passes in that game, which I think may still be an LSU record. I'm not positive of it. But the reason I brought up the football analogy is that's how lopsided this court hearing was. And so I'm just delivering. I could have gone into more. Michael Dubose, who was defending Dakota DeMoss, whose name I am familiar with because he's the one y'all may remember, appeared before the police commission and said, I'm just a dumb old country lawyer from Monroe, but last I checked, state police, you're not above the law. And wound up interrupting Faye Morrison to say, you're wrong, and that got Eula Simeon saying, look, we're going to have some politeness here. It's also Michael Dubose who successfully filed the motion successfully filed a temporary restraining order to halt the state police investigation. My own opinion is Judge Ron Johnson, not to be confused with Don Johnson, but Judge Ron, they're twins, they're twin brothers. My own opinion is he likely signed that thing without even reading it. But once the judge's signature's on there, it's done, and it was in that feature that the despicable language involving the Antonio Harris arrest was revealed, and we published that wound up getting international attention. So I've tried to be as thorough as I can with regard to the Ronald Greene matter and where things have gone from beginning to end. Oh, by the way, and we'll provide a link for this. This is just as kind of as an added FYI. Carl Cavalier has filed notice that he intends to appeal Judge DeGravel's granting of LSP's motion. So we're going to give you that document, but I'm only stating it for informational purposes. It's really got nothing to do with the feature today. But so you'll just have to make what you will of this. But this was a shellacking. And these attorneys are good. They're good. I would imagine that if my prediction, and I'm sorry, that's what I'm predicting, comes about, then the next big question, I guess, both Corey York and John Clary would obviously be back serving as their capacity as troopers, and then the state will have to pay all of the legal fees. And I can just tell you, Mike Small doesn't come cheap, and Norwood Taylor Townsend, but To quote Hugo Holland, it is what it is. There's nothing I can do about, nothing anybody can do about where we are and where we are or may be going. There's no guarantee my prediction will be right. I'm just telling you my thoughts on the matter. And I've tried to give you as objective as I can without going into some of the other minutiae that I could have of what all took place on the June 23rd evidentiary hearing. There is let me wrap this up, last little thing. There is a July 28th deadline for other potential matters. And it was asked of the judge that, okay, you've taken all of this under advisement. Can you give us any kind of general time frame about when we may get rulings on this? And he said, and I want to emphasize that Judge Rogers was very professional and he was even very professional when he, in my opinion, very subtly tried to tell Mr. Belton, you know what, I think you know what. But he indicated that if the timing of his rulings on these would cause that July 28th deadline not to be able to be adhered to, he will certainly push the deadline back. So that's it. If you're a supporter of Ronald Greene and his family, obviously this is not going to be a post that you'll like. I feel my job is to state what happened in a courtroom, and I have, as a blogger, as I said, the prerogative of offering my take, my opinion, and I've done that, and I do believe that these charges are largely, if not in totality, going to be dismissed, and my belief is that that's probably going to happen sooner rather than later. So that's it. Yeah, I guess you got to admit it's been a long time since I made a post, but this is there was plenty of material in it. Thank you once again for your dedicated Sound Off following, and I've got a number of things on my plate that we will be reporting on soon, but obviously this one was pretty major. So if you made it this far into the video, thank you, and we'll just see what Judge Rogers' rulings are on all of these motions to quash the indictments and to dismiss these cases with prejudice. So once again, this is Robert Burns thanking you for your dedication. We'll see you again soon.